Hi, everyone. Welcome. We are going to get started in just a minute. We're going to let people go ahead and join us. Let's give it just a couple minutes here. If you're here live with us, you can drop where you're tuning in from in the chat. I see some people coming on now. Thanks, guys, for joining us today. Hey, Evan, I'm still hearing a little echo. I don't know if anyone in the audience can hear an echo. Can you let us know if the sound and the audio looks okay and sounds okay?
Yeah, move the microphone a little bit further away. Can you talk a little bit more?
Let's do a testing 1, 2, 3. I think we should be okay now. Everyone in the chat saying the sound's great. Thanks, guys.
Okay.
If you hear or see any issues during, just let us know. And we're going to get started in just a minute. Evan, how's the weather there today? You're in Virginia?
It's great. Yeah, I'm in Virginia, just 2 hours south of DC. It's just a nice sunny day outside.
That's good. It's very cold and windy here in New York, which is kind of good. I forgot it's Halloween. So happy Halloween to anyone celebrating.
Yeah, for sure.
Yeah. All right. I see we've got some people joining in now. I will go ahead and get us started. If you guys, we will be taking questions in the chat. My name is Haley, and I am not an immigration attorney, but I'm on the marketing team and the events team here at Manifest Law. And I'm so excited today. We're having a Q&A with Evan, our amazing immigration attorney and a former USCIS officer. So Evan, you want to do a quick intro of yourself for everyone tuning in now?
Sure. So I've been in the immigration law field for over 17 years. I've worked in family practices, employment-based firms, and I worked for the government in the Administrative Appeals Office within USCIS for 7 years. And I'm just loving my time with Manifest, and there's a lot to immigration issues. So I understand there are a lot of concerns people have. So hopefully we can get some answers for you.
Yeah, definitely. And just for housekeeping for everyone, we will be sending a recording of this Q&A out to everyone. It will also live on our YouTube channel afterwards, and you'll get a recap email with additional resources after this if you registered on Luma. And Evan, can you give this? I don't want to give the disclaimer. I feel like you should give it that this is not legal advice, right?
Yeah. So, you need to basically view this as an informational session. Anything we say, I'm almost starting to say, can be used against you. No, that's not right either.
That's
So,
wrong disclaimer.
yeah, that's right. So basically, this doesn't constitute legal advice. So you need to take your own facts and circumstances, verify them against the things that we're saying, consult with an attorney, and we can set you up with some consultations with our attorneys at Manifest. But I have said in the past as well, there are so many details with immigration law. I don't know everything, so I'll let you know where I can be of assistance, and we'll guide you to the help where I can to answer something.
Thanks, Evan. I know everyone's so excited. The last reminder for everyone is this is a public webinar. It's on YouTube. It's on the internet. So please don't share any sensitive information about your case or yourself that you're not comfortable with being shared publicly on the internet. Okay, so Evan, the first question I want to ask you is, if we look at just overall trends recently with EB-1A and EB-2 NIW especially, do you think that we're seeing more RFEs now? And then also, we recently saw the approval rates declining. So I don't know if you could speak to that and just kind of give people a state of the union type view of what's going on with these visas.
Yes, it does seem like we are getting more requests for evidence in both of these case types. I will say from the time I worked for the government, they started positioning things a little bit differently. So as officers, we would get credit for the requests for evidence that are submitted. So when you look at that, and that is the case currently. So when you look at that, there's almost an incentive that an officer has to say, okay, if there's any legal issues I can ask about, it's in their interest to send a request for evidence on that. So it's very difficult to speak to these things holistically because everybody's case is unique, and certainly if there aren't any viable issues to have an officer issue a request for evidence, you should be fine. But I would generally say right now, there in particular, there is this kind of a tightening up of how things are being handled. So we are seeing a lot more of the RFEs being issued.
Got it. That makes sense. And what would be your advice to someone if they are feeling nervous about filing right now? I think I've heard you talk to people in the past about how if you build a strong cases are still getting approved, right? So,
Yeah, the framework has not changed. When I worked for the government, I was there with some administrative changes, some administration changes, and at times there were officers that would say, "Okay, well, we're tightening things up," and I would say, "Well, we have, what directives have you seen?" So, there's nothing out there that's stating, there's been a massive policy shift or anything. Um, and so what I would suggest is still go through your case, very, very closely to make sure there aren't glaring aspects that kind of open you up for an RFE. But you should still have confidence that you can submit a quality petition and have it approved. But
mhm,
again, there are certain times when people are at a certain level in their career where they can file like an EB-1 case on their own. But
yeah,
now it's really recommended that you proceed with an attorney.
yeah, definitely. And I think also working with an attorney is so valuable because if you do get an RFE is not the end of the world. A lot of cases that get RFEs still get approved. And if you already have a great immigration attorney, then you can respond to that RFE that much faster and get your approval that much faster, right?
Right. Yeah,
Yeah.
and I guess a lot of people know this as well, but the premium processing aspect of this also complicates the matter because since the officers have such a limited amount of time to adjudicate the case, by them issuing an RFE, that's also buying them a little more time, or quite a bit more time to be able to adjudicate the case. So that's
Sure.
something to keep in mind as well.
For sure. Okay, well, thanks so much, Evan, for giving us that overview as we get started. We are getting tons and tons of questions here in the chat, so keep dropping them in. I will scroll back up. But to get us started, a lot of people submitted their questions via the Luma registration form. So we're going to start with a couple of those. Um, so, Evan, let's see. For the first question, I'm actually going to send it to the chat so everyone can follow along too. And then you can look at it, Evan, and I think I can put it here on the screen. Um, let's see. Oh, it broke it into pieces. But the question is, are there any recommendations for an atypical EB-1A profile, meaning not a scientist or a tech engineer in tech/business? The way criteria are defined is heavily geared towards academics, scientists, and engineers. How to best communicate the value to officers? They said they're in tech sales with 5 years of experience in a top Forbes Cloud 100 company.
Okay, great question. The way the regulations are laid out, you are correct. There are certain careers, just certain fields that are more amenable to having success with this case type. Sometimes I bring up the issue of like actors have a really hard time with this because you have to show that you've risen to the top of your field, that you have this sustained acclaim. A claim hasn't been defined in the regulations, but the regulations you meet go towards that acclaim. And another part of that phrase is that your achievements have been recognized in the field. And so what I would suggest is really, well, this can come out through, speaking with an attorney about this and trying to pin down what are the elements of recognition that you can point to, what are the criteria that are most in line with what you're doing. One criterion is high salary. So there are a few of these that have this more objective component to them. But then there's also this part of the regulation at the bottom of the list that says if any of these don't readily apply to you, you can use comparable evidence to meet those standards. Now, previously, when I was with the government, virtually, well, it seemed like nobody could use that comparable evidence standard. We just you basically had to show that none out of the 10 were applicable to you. And now the USCIS over the past few years, they've become more reasonable on that. And so you can uh, have a better chance of submitting comparable evidence. So yeah, it's really difficult to know without having a consultation with you about the specific details of your case, but essentially there are uh, these two themes that you need to keep in mind. You have to show that you've risen to the top of your field, and you have this recognition component.
Mhm.
So um, yeah, these are not impossible to meet, but I would suggest just that you uh, dig deep into your past. You know, anytime you can remember somebody gave you a compliment about your expertise, I mean, start brainstorming these ideas and see where it leads you to the recognition that you have. Who knows about the work that you've done in your field
Yeah.
and that kind of a thing. Oftentimes, we tell people it'd be great to have half of your support letters come from those who have worked closely with you, and then to have the other half where it's more objective, it's more from a distance, they know about you and the work you've done. So I'd say continue to network in your field, build up your profile, and we can help you in that process as well.
Yeah, makes sense. Thanks, Evan.
Sure.
I'm seeing so many questions here in the chat. Thank you guys. Keep sending them in. Let's see. I'm gonna scroll up. So, Evan, I'm showing this on the screen, so you should be able to see it. This person wants to know how to know which center has my I-140 petition under the new SCOPS classification for all seats.
Yeah,
Yeah.
yeah, good question. This is kind of a new thing or a recent aspect of these cases. So when you type in when you get your I-140 receipt, it's going to say what service center it's with at the bottom. Um, I don't know exactly if they are specifying whether something is moving on to SCOPS or not. We
Mhm.
do have an attorney with Manifest who recently worked with USCI, so I will get with him on that, and we can give you some more details after the discussion. But
For
yeah,
sure. We
that's
can
all I have for now.
send on the follow-up email. Yeah. Makes sense. Thanks, Evan. Okay. Um, oh, here's a good one. This is we're going a little bit off EB-1A, EB-2, but I think this is a good one. I'm a Canadian on an H-1B with an approved I-140. I commute between Canada and the United States daily. My project ended and I found a new job. Can I work on the TN visa given my prior situation? And they have the
Okay,
approved I-140, so.
yeah, so yeah, the fact that it's already been approved is a positive. So you with the TN visa, it's not a dual intent visa like the H-1B. Um, the and because of that, you would likely run into issues traveling back and forth because once you state your intention to obtain your green card, that's where you need a dual intent visa like the H-1B to allow you to freely travel back and forth. And so, yeah, this would be, um, yeah, I would suggest you speak with an attorney about this, because what you could do, well, I'd like to find out more details, for example, when the priority date is coming current and things like that. Because if it makes sense, if the priority date um, is approaching, you could start that process and apply for work authorization as part of
Mhm.
the green card process. So yeah, Uh, it seems to me like the TN visa is not going to work, but I would
Yeah,
have a consultation with an attorney just to confirm that.
that makes sense to me. Um, Thanks, Evan. Okay, let's see. Um, let's see. Here's a good one. O1 versus EB2 and IW. Is there a what are the differences, and is it possible to just go for the EB2 and IW?
Yes, it is. You still need to be in a valid visa to do the EB2 NIW, but the O1, oftentimes say this is kind of like the little brother or little sister to the EB-1A. So
Mhm.
they're both extraordinary ability visas, but the O1 extraordinary ability visa is a temporary or non-immigrant visa. They give you that for 3 years. Um, that's also a dual intent visa. Um, and the approval rate of those are much higher. Um, but it's basically the same standards. You have to meet 3 out of 8 of criteria. With the EB1, you have to meet 3 out of 10 criteria, but also it's a higher burden to show you've risen to the top of your field. With the EB2 NIW, this is a way to get around the labor certification process if your proposed endeavor is in the national interest. And so um, both of these can be stepping stones toward an EB-1A. So a lot of this is going to depend on what your field is, what your proposed endeavor would be for the EB2 NIW. You could
Mm,
also try for both of these at the same time. One significant difference I um, remind people about between the extraordinary ability visas and the EB2 NIW is the extraordinary ability visas focus on what you've already accomplished, the level
mhm.
you've already achieved in your field. The EB2 NIW is more forward looking. What are you going to accomplish? It still does look at your expertise because you have to show you are well situated to advance the endeavor.
Yeah,
But it can have a much more prospective, forward looking aspect to it.
yeah. That's a good explanation, Evan. Thank you.
Sure.
Um, Good question. Thank you guys for continuing to drop your questions here in the chat. Um, let's see. Oh, I like this one. From your perspective, since there's a huge gap between your approval, I'm going to assume of the I-140 and the I-485 for certain countries, do you need to maintain your sustained a claim so your I-485 is approved?
Yeah, question. So at the I-485 stage, the officer is not re-adjudicating the I-140. At least
Hmm.
they shouldn't be, and in most cases, they're going to have kind of their blinders on in terms of they're going to have the I-45 pulled up, and that's their focus on, all the questions. What's your employment history? Where have you lived for all these years? What's your travel history like? Are you a national security threat? All of those. So the uh, yeah, so the overarching question is, you know, I guess one way to look at this is do you or would somebody be at risk of having their I-140 revoked if, for example, somehow it came out that you weren't maintaining the claim? What I would suggest is just continue in your field, continue to network, continue to do public facing things to have recognition in the industry, just as a precautionary aspect. If, for example, the officer does ask you, so what are you doing now in your career? Or and if it's completely changed to what you'd been doing for the EB-1A, that could be a problem. So I would say it's not likely to be an issue. The sustained acclaim aspect is what you need to get the approval. There really is not, it's such a subjective aspect of the case, especially because the regulations go towards establishing a claim and the regulations don't really define what a claim is. And so because it's so subjective, I really doubt that an officer is going to say, wait a second, you need to show that you've maintained that to now.
That makes sense. Yeah. Thank you, Evan.
Sure.
Um, All right, let's see. This is a good one. Diego is asking, how does processing time change if pre-em processing is done, but the case is RFE'd? So I'm assuming, I mean, I think a lot of people would want to know is, does that pre-em processing still apply, and how quickly they reply to your RFE, or let's just talk about that.
Yes. So what happens with the premium processing? So I'm talking about EB-1As. Really, EB-2s, it's 45 days for EB-2 NIWs, or 15 days, 15 business days if it's EB-1s. So what happens is the moment that the RFE is issued, um, that basically puts a stop on the timing in which they have to adjudicate the case. And so then you respond to the RFE, and then what they do is they start another clock, starting another 15 days. So I think sometimes people think, okay, if they issued it at 13 days, then when we respond, they have 2 more days to finish it. But that's not the case. It starts another 15-day period. And like I was saying earlier, that kind of shows you there is an incentive here for them to issue the RFE, as it buys them more time and onward. And so with the EB-2 NIWs, you get 45. They have 45 business days to adjudicate the case. Same thing. Once you respond to the RFE, another 45-day clock starts.
That's super helpful. Thank you for clarifying, because I always thought they had those 2 days to reply,
That
but
I know that would be nice.
no.
And a while ago, they changed it from being calendar days to business days because they were trying to do anything they could to give their officers a little more time. Because if they
That's actually
don't,
smart.
yeah, because if they don't issue a decision by that time, they have to refund those fees, and they don't
Uh,
want to do that.
of course, that makes sense. Okay, let's see. Here's one. On my NIW RFE, the officer seemed to ignore a lot of evidence I provided. They claimed I had no patent. I provided evidence for two. How can I ensure the officer actually reads my response? I love this question, Evan, because you've told me sometimes they send those templated responses, and I know you have some good stories. So,
Yeah, great question. Now, this just triggered a thought in my mind: is we need to ensure that they have body cameras on later on. No, that would be awesome. Then we'd know what pages they flip to, right?
that would be super helpful.
Yeah, right. So the challenge, especially with the premium processing, so I have to be careful because because I have stories that I could share from when I worked for the government. So, um, what I would suggest, so this happens a lot because these cases involve a lot of evidence, and these officers do this day in and day out. They're scanning through things, and with the time crunch, they just don't have time to go through everything. The other challenge with this is that they have these template RFEs or they may have saved an RFE in another case and they're just trying to rework it. I mean, sometimes it gets really problematic when you get an RFE and someone else's name is included in there even. So, um, yeah, it's frustrating. I see this type of thing happening quite a bit. So, how can you ensure the officer actually reads your response? What I would suggest is, so when you give the response, there's a couple ways to go about this. I've seen some attorneys just go really hardcore and get it together, people, like really coming hard with some really kind of abrasive language. My suggestion is to be respectful and say, kind of in bold at the top, respectfully, we point you to this evidence that was submitted the first time that shows two patents were provided. In other words, you need to remember that this is still an art of persuasion. And so you really don't want to, um, kind of come at the officer with guns blazing. That doesn't really put them in a positive uh, kind of position to say, okay, yes, now I see, now I'll approve this. Potentially what that does is has them say, okay, well, sure, you meet this, but now I'm going to bring it to you on these other claims or these other aspects of your case. So the other thing I would suggest is just making sure that the details you provide are very clearly highlighted in your cover letter. Sometimes it doesn't look all that professional to even just take a regular highlighter and just highlight through it, but it's helpful for the officer when those things stand out. So if you don't do that, a lot of times the way I prepare things is I do put a lot of things in bold and underline, just to ensure that they see that. The other thing I would say is you don't necessarily need to present things in the order that they've given, but in an RFE, I recommend you actually do that because they're kind of going down the list of have you responded to everything I asked for. Sometimes strategically that can be difficult for attorneys because we want to put the most impactful things first. But so there's a strategy there, but I would recommend you follow the order they have and then just bold and highlight the things that are most critical.
That makes sense. Yeah, I think a lot of people overlook the importance of the presentation of the case, but they're distracted human beings just like we all are, right? Yeah. Okay. Let me see. Our next question, let's see. How about this one? Bright said, is a proposed endeavor targeted at helping a federal organization like the CDC achieve its research goals a good proposal?
So, good question. Anytime there are endeavors that can be impactful to federal organizations, that can be a very positive thing. The nice thing about EB-2 NIWs is there aren't any limits to what you can propose and what can make a good proposal. And so, um, when when you look at things like this, especially if you had details about the limited number of researchers that they had, or if there's other specific details about your proposal that show there's kind of a gap in what you're trying to fill. Oftentimes, I compare the EB2 NIW to kind of the business world in general. You oftentimes well, even when I was growing up, a very good friend of mine her father just recognized this position at a bank and just decided to go position uh, his uh, his idea to open up this new uh, job title for him to fill, and it worked, and they went for it. And so this is a similar kind of thing with this visa. You're proposing an idea, that an endeavor that you feel like has a lot of value to the country. And so then the next part of that is what is the evidence you can provide to support that. So it's one of these things that it's not a one size fits all type of a thing, but this sounds like this is something that could have uh, a positive impact.
That makes complete sense. Yeah, that's a good one. Here's a fun one, Evan. Sunny says, how does Evan decide which case has a potential for EB-1A or if they need to build their profile more? So when you're meeting with a potential client, what are some of the questions you ask? How do you decide?
Question. So the first thing I do is I look at what are the criteria that you're likely to meet without having any issues, because we need to get you to at least three. The more you have, the stronger of a position you're in, especially because sometimes officers take issue with things that, in my view, can be ridiculous. Um, so Th there are 2 components to this, though, because in the back of my mind, I'm thinking, what are the aspects of this evidence that go towards showing you've risen to the top of your field, and what are the ones that you have showing recognition? Sometimes positions like engineers, they won't have the outward-facing things that you'd expect to see in other positions like researchers and others, but, at the same time, they may be well known in their field for the components they're working on, or the designs they've developed. And so usually it starts with do we have enough to show that you meet at least three out of the 10 criteria? And then my next question is going to what we call the final merits analysis, which is after you show that you've met at least three, then what the officer does is they say, now, does the evidence submitted, does the quality of it match the level that we would expect to see for this classification? In other words, do you meet these two themes, which shows that you've risen to the top of your field and that you have this sustained acclaim? And so if I am struggling to see what we can point out about recognition in the field, that's when we're going to suggest you work on building up your portfolio more, networking with others, trying to see if there's conferences you can speak at, seeing if there's awards that you can apply for, and other things like that. There are other aspects of this that do show recognition, even with a high salary. That's your employer is showing that you're being recognized for your work in the field. So that has an element to of recognition to it, but we'd like to see much more than that, obviously. So, but usually, because I've adjudicated these cases, usually I can tell pretty quickly whether it's one that I feel comfortable moving forward with, whether it's one we think we'd likely get an RFE, but they still will likely succeed, or whether it's one that really needs a 6 month to a year or more time to build up that portfolio.
What would be a sign to you that it was a strong case that would still get approved, but it probably would get an RFE? Like, how would you know?
Oftentimes with those, it will be, there are three criteria like the awards, the membership, and the judging that they just are not as strong right as the other criteria in my view. And officers tend to try to diminish them in a number of ways. Sometimes people run into issues where, let's say they have 4 awards, but only 2 of them have kind of this national renown effect. But if you present all 4 of them, you're likely to get an RFE talking about the other 2. And so in my view, it's best to just leave those other 2 out, right? Um, and so the other thing I would say is, when I brought up like the engineers, if they've published scholarly articles, their Google Scholar page is going to say how many articles they published, their citation level. If officers aren't trained very well, they may be comparing that to researchers that have a lot of citations, and so automatically, because of the field that person is in, they might be susceptible to an RFE. That's more of a training issue, but so there's conversations like that I usually have with clients where I just say, just so you're aware, this is the situation. You might expect an RFE on this. Here's what I suggest we do to prevent that from happening.
Yeah, that's really powerful. Thanks, Evan. Especially the part about it's so interesting what you said about not including those 2 weaker awards. Like I think I've heard you talk a lot about how you don't need to always present every single piece of evidence you have. You really need to go through, and that's what an attorney can help with is choosing the strongest evidence. Yeah.
Definitely.
Awesome. Okay, let's keep going through these questions, guys. Um, let's see. This one is interesting. Can they send you another RFE after you respond to the first one? I never thought of that.
Yes, they're
Oh,
unlikely to do that because if they send another RFE, they have to get their supervisor approval for it. And at that point, the officer's saying, "Oh shoot, I should have thought about this the first time." But this is actually one reason why you do oftentimes get a very lengthy RFE because
mm,
the officer wants to make sure that they don't have to send another one. And so
mm,
think about this, there really needs to be something changed as far as the officer's incentive so
yeah,
that because they're short on time, they have these maybe 6 to 8 or more criteria that you're discussing, a whole lot of evidence about all of them. And so they're quickly trying to see what deficiencies does it look like there are here that I can just include in this RFE. The other thing is the officer doesn't want to just issue an RFE for one thing. It's just kind of seems like I don't know that that doesn't happen very often. And so usually if the door gets open for one thing, they might start digging for other reasons for what they can request additional evidence on. So
Mhm.
yeah, so they can send another one, but it's unlikely. It does happen sometimes, but usually not the case.
Yeah, yeah. Okay, that makes sense. That's super interesting. I never even thought of that. Okay, let's see. I don't know if you can answer this one, but because it's can vary so much, but if you don't use premium processing for EB2 and NIW, how long do you think the decision time is expected if there's no RFE?
Good question. So I did some consulting on some cases um, within the past 2 years, and um, it seemed like so let me state something a little more broadly as well. Sometimes I encourage people to go the regular processing route for EB1s because it can help them continue to build out their portfolio. Or if I just felt like their case was not strong enough to withstand the very short time of the scrutiny that the officer gives it. So there were times when I worked at the AAO that I really grappled with some cases over a period of time because they were so close in some ways, and yet there were other things that weren't quite there. But because I had more time at the AAO in adjudicating that, ultimately I came down and said, okay, this is how I clearly see now. This is where they meet the standards. Sometimes that can happen with regular processing as well. It also depends on the officer. If they have a huge caseload and they're just, you know, trying to get through things as quickly as they can, that can be problematic. But with this other case that I'm referring to, I suggested this person take the regular processing route, and then it was a year and a half later, and I was still getting emails saying, "I haven't heard anything yet." And so it's hard to say. It there were times when I adjudicated cases at the AAO that I would get a case and realize, oh my gosh, this has been sitting on a shelf somewhere for 2 years, and I could have made a decision here within 30 days or something. So that doesn't happen all that often, but uh, um, and I have, over the years, I mean, USCIS is making a lot of improvements and trying to be more efficient and things like that. But what you can do is you can file these under regular processing, and then you can bump them up to premium processing if it just starts to take too long, and then that puts you on uh, a a better clock, and you understand the timing from there. And that can also be beneficial in that, if there is a request for evidence and especially in the EB1 case, and you were able to build up your portfolio more, you might have more evidence to
Mhm.
respond as well. So these are good strategic questions to uh, talk through with an attorney, but yeah, that's the main challenge with the regular filed just cases is you just don't know how long it could take.
Yeah, that makes sense. And it's good to know that you can always upgrade to premium processing later. Yeah. Okay. Thank you, Evan. That one was helpful. Let's keep going, guys. Keep dropping your questions in the chat. Um, let's see. This one's interesting. Should you consider downgrading from EB2 and NIW to EB3 if the EB3 I-140 processing wait times are less? It's interesting.
That is an interesting question. So I I wouldn't consider downgrading because of all the work that you put into the EB2 NIW.
Mhm.
Um, and so, the wait times uh, are lower for the EB3. That could change at any point as well too. So I would suggest not doing that. Now, whether you when you know when you're downgraded from that, I mean, so the EB-3 is going to require the labor certification process, and so in my view, there is a challenge there because you can file both. On the one hand, you know, you're filing an EB-2 NIW to say a labor certification is not required.
Mhm.
Here's why I'm asking that that be avoided. And then
Mhm.
for you to file another petition where you do file a labor certification, they
Yeah.
kind of have this like magnetic pull against each other. So I would suggest not doing that, but if yeah, I would talk with an attorney about that. In other words, if you were very confident that you could make it through the labor certification process and come out ahead, um, you know, time-wise, much better off than waiting for the EB-2 NIW, then that might be worth it. But by filing the EB-3, you might be just hurting your chances with the EB-2 NIW.
Yeah. That's again one place where talking to an attorney is so helpful because they can talk through all these timelines because that's the trickiest part I know for a lot of people. Um okay, Evan, let me see. I'm going to go through here. Um let me see. I'm getting so many questions. Thanks everyone. Um let's see. This one, I think I understand what they're asking. Should the response to an RFE be one-to-one comment or a complete narrative? For example, they have 5 comments on national importance. Does that question make sense to you, Evan?
So, um, you know, what you want to be sure of is that the officer is aware of the fact that you've responded to each of the things that they're asking. So when you're asking about a complete narrative, my sense is it would be better to have this one-to-one comment and answer aspect of this rather than a complete narrative. The officers really start to get thrilled when they see something short for them to
Mm,
read. You know, I was having a consultation earlier with someone and I said, this is actually a really good letter because we can condense this to one page and only half of the page, and it has a lot of really good content in there. So um, I would um, again just say the one-to-one comment is better. Sometimes I have some dialogue with my clients about the ways I, you know, lay out my drafts. And oftentimes I'll tell them, listen, you're probably going to be expecting a really formal looking piece, but oftentimes I do bullet points and we just want to get right to the heart of the matter. So um, that's what I would suggest. You can still have you still want a polished look to it and everything, but this kind of one-to-one aspect is really helpful for the officer to see that you've addressed it, you're aware of the issue, and that you're pointing to the evidence for what they're asking for.
that makes sense to me. I know that that's how I like to read things personally is bullet points straight to the point. Yeah.
Yeah.
Um let's see. Um let's see. This one's a little bit interesting. Um, does a home service business franchise owner in the US on the E2 visa have a chance at an EB2 and IW? And is the E2, Evan, this is just for me, is that dual intent or no?
Yeah, so the E2 does have a dual intent. It's kind of like the O1 where it's not complete dual intent like the H1B, but it's like the functional
Not
equivalent
prohibited.
of it.
Yeah.
Yeah, so yes, this is something that you could pursue. Um, you know, just by being on an E2 visa, it's an investor visa, and so with just that alone, you're already having a benefit on the economy,
Mm,
and so um, basically by framing what your proposed endeavor would be, you would want to um, basically add more value to what you're already providing, granted, because you're already on the E2 investor visa, right? But if you can formulate your proposed endeavor to demonstrate even more value that you're able to add to the economy, showing why it's in the national importance, that it has substantial merit. Yes, that definitely can be something that is worthwhile to pursue.
Definitely. And as we're getting a little bit closer to our time, I just wanted to, we still have a few minutes here for questions, but I just want to let everyone know I dropped the link to request a consultation with Manifest Law. And as a thank you for attending this webinar, we're also giving $250 off any case. So if you go to that link and you request a consultation with us, then we can get you set up there and to talk to an attorney about your unique case. But we will take a couple more questions here. This one is interesting. Evan, how many published papers and judging events are required for EB-1A?
So there's really not a set number for any of these, but like I was saying earlier about certain fields, like engineers, they're not generally going to have as many as others. So, you know, there are certain numbers I remember hearing officers talk about. For example, just generally, I remember hearing officers say, "Well, I like to see about 30 citations to their scholarly articles and things." And what I came away from a lot of that is thinking, well, that's your personal viewpoint. I mean, um, have you thought about the fact that the regulations don't require that, right? You have to just show that you have scholarly articles published, right? If you have judging events, if you have two of them, well, that becomes plural, right? There are also issues or conversations that I remember hearing about where people would say, well, what if they just have one scholarly article and it says scholarly articles, right? So those, I mean, those are kind of splitting hairs. But what I want to go to show you as far as how this is utilized is the fewer of these you have, the more you put yourself at risk at the final merits analysis. Because what the officer is going to do is they're going to take the weakest part of your case and they're going to say, okay, well, you've submitted this evidence that you've judged here, but you've only done it on two occasions. And these occasions, we just don't feel like those were very prominent in your industry, right? And so they're focusing on that. And so the more you have of any of this, the better off you are. But there isn't a set number of any of these. And so what I would suggest is just continue to build up your portfolio with things that are impactful for you. Like if these judging events kind of ruined your life, well, maybe don't focus on those ones. Look at some of the other ones. Maybe see if you can get some published material about you. Oftentimes, that can be a positive thing. The published material about you is one that is it's harder for the officers to come back and say, well, this is kind of uh, you know lower level. There is a difficult component to that because if it's not in professional or trade or major trade media, you have to show that it's in major media. So that can be a difficult one to meet. But basically, I would suggest just the more you can become published with scholarly articles, the more articles you can have written about you, the more judging events you can have. In other words, you want to almost take that approach that teams would say, we're only as good as our weakest member of our team. Your case is only as strong as your weakest aspect of the criteria, right? And so the more you focus on shoring those up, the better likelihood you're going to have success.
That's a really good metaphor. Would you give the same advice for membership? Someone here asked, "Are there how many memberships are good enough?"
Yeah, so there's this fine line between what I was discussing earlier about also making sure that you don't include some of the weaker aspects of these. So the challenge with the awards and the memberships is that they have certain components with them. So with memberships, you have to show that you received the membership because of your outstanding achievements in the field and that it was judged by nationally renowned experts. And so if you have a hard time showing how it was that you obtained the membership, or who adjudicated that, or if you can't get the bylaws that show what the requirements are for the membership, that can be challenging. So it's a similar thing. What I suggest is just ensure that the memberships and the awards that you are submitting, I'm adding awards in this, but ensure that the memberships you are submitting um, meet all of the aspects of the regulations that prevents you from getting an RFE. And what happens if the officer issues an RFE, they've already started drafting a denial. This is one thing I just want to make a quick comment on really quickly. Especially the longer the RFE is, the officer can take everything that they wrote in describing the evidence you've submitted, and they can just copy and paste it into the denial, and they're already down that path. And so that's another reason why you want to do everything you can to avoid an RFE, because it gets them in that mindset of, okay, we're going down this path. They haven't shown me enough to overturn this.
Yeah.
So anyway, there's not a set number on these, generally you want to have at least two, but you can meet it even with just one. I wouldn't recommend it because that's what they will bring back on the final merits, but hopefully that makes sense.
No, it makes complete sense. Thank you so much, Evan. Um, well, I think we are going to wrap up here in just a minute, but Evan, what is your like final advice to anyone in the audience who is considering applying for EB-1A, considering applying for EB-2 and NIW? Maybe they're worried about an RFE. What are just your final words of advice besides, of course, request a consultation with an
Yes.
attorney?
Well, first of all, I would suggest that you have a positive mindset, even though we know that some of the numbers, well, the numbers have come down in the approval um, rates. You can't get around that.
Yeah.
But I would suggest just take a moment to see where you are in your career and where you envision yourself in a year. If you see that there's really not a lot of development. So let's say, for example, you've already published 5 scholarly articles, and you think in a year maybe you might get up to 7. That doesn't really change a lot, in my view, from an officer's perspective. And so, but then take some time and think, who are the people that can write support letters about the work I've done in the field? If you feel like you have a good amount of evidence to meet these criteria, I'd say go all in and try for it. Oftentimes, I tell people to be cautious in that having a denial can kind of impede their progress in the future, or in other words, it can be almost a stumbling block sometimes, where officers see that and they say, well, it's been denied before, what changed? But on the other hand, I remember approving many cases that they were denied the first time around. By having you go through the process, you do get closer to that approval. It's similar to a lot of other things. When law graduates fail a bar exam, you as they got closer to it, they gained more expertise, even though they didn't succeed the first time. They try again, they get closer and closer until they pass. So there's a lot of things like that, but I would say just move forward, continue to build up your portfolio, your expertise in what you're passionate about, and then with EB2s, just look for ways you can add value to the country. And if a number of attorneys say, I don't think you have a shot, try to get a second opinion. Maybe there's something that other attorneys might see in the value you're offering to provide. So anyway, I would just say best of luck, and let us know if we can help in any way.
Yeah. Thank you so much, Evan. That was really, really good to hear. I'm sure everyone appreciated you taking the time to answer all these questions. I'm dropping the link again in the chat one last time for you guys. As Evan said, the best way to get the answers you need is just to request a consultation with an attorney. We will send everyone a follow-up email with a link to this recording. And we appreciate you so much for being here, and we'll talk to you soon. Thank you.